And the recording has begun. I have 5:34. Chair Schmidt, would you like to introduce the meeting or do you want me to?
I go ahead, Ms. Leger. You can do the introduction.
This is the Complaint Committee of the Sunshine Ordinance Task Force. This is a remote regular meeting. The listen public call-in phone number is 415-906-4659. The meeting ID is 793-509-125#. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Please also note that callers may now raise their hands by pressing *5. Today's date is April 19. The time is 3:35. Remote access to information and participation. In accordance with Governor Newsom's Executive Order number N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Reed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. That's CHERYL.LEGER@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, do you want to read meeting decorum?
Yes. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. And so we can move on to number 1.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Stein.
Here.
Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. We have a quorum. I am not aware. Well, there is a possible agenda change.
Okay.
I think once we get to that particular item, we can discuss it. I don't think it's a good idea to bring it up now.
That sounds fine. No
right.
changes.
Can I ask, I don't know if this is possible, but I noticed that files 6 and 7 seem to deal with the same request, and the petitioner themselves suggested potentially combining it into one hearing. And I'm wondering if we can do that.
The petitioner called me today and said that there were some materials missing from one of his cases, 22014. He said they were missing from 22020, but they were in there because I double checked today they were, and I remember inserting them into the file.
Right, but I'm asking about, can we combine?
I think that's Victor, if I'm wrong, I think that's a matter for the task force to decide. Am I correct on that? My thought was this: if Mr. Severnov says there are materials missing from 22014, that maybe we want to push those 2 cases to another task force complaint committee hearing.
Let's yeah. I would say we handle it. I think they should be handled together. They would be combined in any circumstance because to me it looks like it should be the same file. But if there's missing documents, why don't we wait until the number is called to figure that out? Is that all right with everyone?
That's fine with me.
Okay.
Victor, what's your opinion?
Yes, sorry, I had my mic off. But yes, I was wondering, was this the case where they submitted additional documents regarding the same issue a little bit later and we just opened another file or not? Normally it is that we don't, we do need to get the permission from both parties before combining anything. And recently I believe it's at the discretion of the full task force whether or not to combine. It's just easier to schedule them both at the same time and deal with them at the same time and treat them like the same file, even though they have different numbers.
That's fine. Yeah, it's all the same. I guess we'll spend a little more time on it. Which is
if that's, excuse me, Mr. Severanov, I'm the petitioner.
Mr. Severanov, we'll handle it when we get to the case. I think there's enough here that we can figure out what we need to do today, and we'll just see if the parties can be brief when the second number is called, because we're trying to be as efficient as we can today. So, yeah, Mr. Severanov, we will be hearing about the case, but let's wait for that number to be called. Let's go in order.
Okay.
So number 3, Cheryl.
Hang on a second. Okay. So we're done with item number 1 then? Oh, Laura, did you have something you want to add?
Yeah, I'm just saying we're going on to number 2, not 3.
Yeah.
Oh, I'm sorry. Yes.
That's okay. That's okay. Item number 2, approval of the March 15, 2022 Complaint Committee meeting minutes. Do we have changes? I have the minutes right here.
This is Member Stein. I'd like to suggest one change.
Okay.
Which is to add to item 7 on P5, the 5th paragraph down.
The action?
The sentence, it starts with a Q&A period occurred, I believe.
Right, okay.
I'd like to add there, Member Stein asked the DPH representatives if they were aware of any DPH reports on COVID-19 infections at Oracle Park during the 2021 baseball season. I mean, I can also email this to you, Cheryl, but I
was going to say, email it to me if you can, okay, and then I will insert it into the minutes.
Okay, I'm going to just finish it and then I'll email it to you right away. So just to say, Member Stein asked the DPH representatives if they were aware of any DPH reports on COVID-19 infections at Oracle Park during the 2021 baseball season. Ms. Tran responded that she was not aware of any such reports. So I'm about to email that to you, and that's my suggested change.
That's your inclusion. Okay, that's great. I wrote it down in my notes to look for it, and I think we're good. So we want to let's see, item number 2.
With that change, I'll move to approve.
I'll second it.
Okay, moved by Member Schmidt, moved by Chair Schmidt, seconded by Member Stein to approve the March minutes with suggested changes. Do we want to open this up for public comment?
Yes.
This is public comment on the motion to approve the minutes. If you'd like to make public comment, let me know.
Anonymous number 3.
We have 1. Do we have 2?
Do we have more public
This is Mark Norton.
Mark Norton.
Briefly.
You'll be second.
Great.
Okay. Do we have other public commenters?
Let's go with that for now.
Okay. Anonymous, are you ready to begin?
I am.
Go ahead.
Thank you very much. Good evening. This is anonymous number 3. I suggest there's a number of things that need to be corrected in item 8, and I would actually suggest that you delay approval and go back and listen to the actual tape before you approve this. So under item 8 on page 5, the second to last and last sentence of my testimony don't really make sense, and they're combining two different issues. The supervisor of records, I never said it is required to issue an order that there are no records. I'm not sure what that means. I said separately that the supervisor of records is required to issue orders, and also that the supervisor of records was required to give me a 6721C statement that there were no records. So they're two different things. And then it disclaims that the city attorney's office admitted a violation of 6721C. And as much as I would love if that were true, I'm pretty sure they did not do that in the last sentence of the city attorney's testimony. And the motion, which is the most important thing, that I don't believe those are the reasons for the three different sections there. So the last one doesn't make any sense. 6730C defined appropriate ways in which to implement this chapter. I'm fairly certain what Chair Schmidt said is that was under your authority under 6730C to refer to an enforcement body when you determine that a person, in this case, the city attorney, Dennis Herrera, violated the Sunshine Ordinance. But I would strongly urge that you do not approve these minutes today and go back and listen to the tape and fix up item 8. Thank you.
Thank you. All right, let's let's go ahead and hear from Mr. Norton, although I'm going to withdraw my motion based on what I just heard, but go ahead, Mr. Norton.
Okay, I was actually just...
When Cheryl starts the timer, I'm sorry.
Okay.
Yeah, Mr. Norton, are you ready?
I am.
Okay, you can go.
I was just going to say thank you for making the change to item number 7. I hope there's a way, but I'm going to have to add now, I hope there's a way, if you need to delay the approval of these minutes with respect to item number 8, that you could carve that out and approve the rest of the minutes so that I don't have to come back next month to make sure this all comes out right. Thank you.
Thank you. I think that I believe at this point, for all purposes, even though I do withdraw my motion, we're not going to end up making any changes other than to number 8, unless for some reason, someone else comes in with something. But I'm sure that the language that we changed in number 7, I think it was number 7, is secure. But I do take so Mr. Norton, your changes will be made. Anonymous number 3, I think that those are substantive changes, and it is something that I think is it's a significant case to me because we're dealing with the supervisor of records, and I've been looking at the issue of what the level of responsibility is of the supervisor, and so I think we do need to get the minutes correct on that case. So I would draw my motion, and I'm going to move that we continue the matter to the next meeting in order to adjust the minutes in accordance with the public comment received from anonymous number 3.
I'll second that. This is member Stein.
Okay. And at that, I guess what we should do, since it's a different motion, let's open it up if there's any further public comment on the continuance.
Hello. I would like to comment on the original motion, please.
That's closed.
I was waiting in line the whole time while it was being discussed.
Oh, so we had a third public commenter But I guess for some reason, I think we should, I know it's closed, but for some reason, technically, I think, and I think we do need to go back and listen to that public comment.
Mr. Anonymous 3's public comment?
No. This would be the third public comment on the original motion, because I know that the motion's been withdrawn, but I think we didn't catch the fact that we had a third person, and it may be for technical reasons. So I want to be flexible on that ground. So let's go ahead.
All right, Mr. Warfield, are you ready to begin?
Yeah.
Mr. Warfield?
Yes, let me know, please, when to start.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. I want to thank the chair for what he just did. I did not hear anything about comments closed. You started with 2 people being allowed to comment on the original motion, and I don't think that it should be a matter of flexibility. I think it should be a matter of right, that a member of the public who wished to comment on something that already has been commented on by others should also be able to comment on that item. And if you're going to change the motion, I'm actually glad that you're going to do that. But I'd like to comment separately, as the other 2 will have an opportunity to do as well. So on the original motion, I agree with the previous 2 commenters, and I'd like to add that I consider it vitally important that you not make changes invisibly, but that any and all changes be openly presented and discussed, or at least presented, for when you ultimately are approving minutes. It seems to me that there have been times when people say, oh, I'll make that change, or I'm aware of that change, and so on, but we don't hear what it is. We don't hear the exact wording of what is going to happen to the minutes. And I think it's crucially important so that everybody who is able to comment or discuss or vote on the minutes will know exactly what the changes and the corrections are. And it's also important for people to know that previous minutes that they might have read in draft form have errors and corrections that you've agreed to and exactly what those are. Thanks very much.
Okay, thank you. Now we can move on to public comment on the second motion.
Hi, this is Mark Norton. May I comment?
Yes. Let's see if there's anyone else first. Okay, Mr. Norton's number 1. Is there anyone else who wants to comment on the continuance motion? Okay, let's go ahead with Mr. Norton.
I'm sorry, did I hear somebody in the background say they want to comment?
Thank you. I believe I'm not clear what's being discussed. A motion to continue till the next meeting. Is that right?
Yes. In the meantime, we're going to make some changes to number 8, but it's a motion to continue this for approval at the next meeting.
Yes, please. To comment.
Thanks. So we have 2 commenters. We'll start with Mr. Norton.
Should I go now?
Wait a second. Are you ready to begin?
I am.
Go ahead, sir.
I just want to request that the change to item number 7 be included in the draft minutes, which are posted on the website for the next meeting. Thank you.
Thank you. All right. And then the second public commenter. When Cheryl's ready.
Mr. Warfield, are you ready?
I am. Just say when.
Go ahead, sir.
This is Peter Warfield again. We're Executive Director of Library Users Association, Library Users 2004 at yahoo.com. And also P.O. Box 170544, San Francisco, California, 94117-0544. I say that for a number of reasons, but above all because I consider it's an important part of a public comment opportunity in general in real world and should be in the virtual world. I'm not clear about what the chair apparently just said before we started with public comment, that something about changing number 8. So does that mean we're going to have a different draft that will already incorporate a change that was discussed today but not voted on? And are there any other changes going to happen to the draft so that ultimately what we have is a second document, a different document from what was brought to this meeting? Once again, I think it's critically important that people understand what they're looking at. If it's a second version, then it needs to be clearly labeled that way. But the process by which it changed hasn't had a vote. So I think it's a little confusing there as well. I can also say that draft minutes can be very misleading for folks. I certainly have heard of a case where somebody was trying to get in touch with somebody and followed what the draft minutes incorrectly said and ended up unable to get in touch with somebody. This was prior to the correction. So I think it needs to be noted and clear exactly what the changes are and whether they've been approved or not, and so on and so forth. I think it all needs to be public. Thanks very much.
All right, thank you. All right, I think we are closed for public comment on that matter, so I think we're ready for a vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to move that we continue the matter to the next meeting of the Complaint Committee, adjust the minutes and adjust the minutes in accordance with suggestions of Anonymous 3.
Shouldn't that also, we might want to say adjust adjust the minutes on number 8 and also adjust the minutes on number 7 as suggested by Member Stein.
Yes, let's make that clarification. That's absolutely correct.
Okay. Changes in the motion have been duly noted. Moved by Chair Schmidt, seconded by Member Stein, to continue the matter to the next Complaint Committee meeting to adjust the minutes on item 7 as suggested by Member Stein and make suggested changes in accordance with Anonymous 3 of item 8. Okay, ready for the next item?
Yes.
Okay. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Is there anyone who would like to give general public comment today?
Anonymous number 3.
Okay, so we have a public commenter, general public comment. Anyone else? Let's go ahead with anonymous number 3 when Cheryl's ready.
Anonymous, are you ready to begin?
I am.
Go ahead, sir.
Thank you very much. This is anonymous number 3, and as often, I'll just talk about some general sunshine issues that the city is doing poorly. The redistricting task force is a public body. Its members are public officials, and they have to maintain their public records. And so I've been sunshining regularly, essentially all of their communication with each other, the supervisor's office, the mayor's office, and most of them haven't produced anything. In fact, one of them claims that she has no responsive records. This is the vice chair of the redistricting task force for all these kinds of communications, where we know immediately before that, these members were communicating with each other. Other members have produced some of those copies. And worst of all, that request has within its scope of responsive records, the other records requests I have made to them. So if she's telling the truth, she has destroyed during their pendency while a request was open, the records for a request, which is, as the Good Government Guide tells you, unlawful. And this is the extent to which certain SF public officials will go to ensure their communications cannot be read by the public. This is certainly not specific to the redistricting task force. The mayor's office throughout the executive branch do it. At least one supervisor, Melgar, does it. This is just how the city of San Francisco operates to ensure that the public does not know what its officials do. Thank you.
Okay, thank you. Is there anything else here for general public comment?
Yes, please.
Right. So we have one more, Cheryl, when Cheryl's ready.
Mr. Warfield, are you ready to begin?
Yes, just tell me when. I didn't hear anything. I'm sorry. What?
Hang on a second. If you're making all that noise on your desk or your phone, could you please mute yourself because it's disturbing the public commenters?
How's this? Am I doing okay now?
Yeah, but I was hearing some background noise, and I was trying to get whoever was making it to mute themselves. And it looks like they have. Okay, let's start again.
Yeah, just tell me when you're starting your timer.
All right, you ready, sir?
I am.
Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. I'm glad that the previous speaker mentioned what's going on with RDTF. There seem to me to be very unfortunate things going on, including some direct violations of sunshine. One of the difficulties is that with the slowness of the sunshine process, they're very likely to be done with their entire business long before you can have a hearing or any kind of a determination. Now, that's not necessarily your fault, but it is a problem in terms of how we're having the decision made about one of the most important things in our democracy, and that is whether people will have fair districts, fair representation, and a fair right in a democratic society to be represented. And I can certainly say there are a lot of people that are very unhappy with what's going on. Things that I've noticed, for example, are that in the agendas, multiple agendas that I've seen, there has been no mention of explanatory documents of any kind. Either ones available, such as for Thursday's meeting, which had something like, 9 days or so a week anyway to get set, nor that there might be something last minute and here's how to find it. There are a variety of other issues, but in particular, I've had the experience of long meetings, including one of the meetings I made my last public comment at 4:04 a.m. But they have explicitly refused me public comment opportunity once by the chair, and at other times simply not called on me, even though I had my hand raised or was in the speaker queue or should have been. And that's a serious problem. Again, I'm not sure what to do about it because any resolution would happen after they're all done. Thank you very much. I think my time is up. Is it?
Close.
Close. So yeah, those are some serious problems in an important arena of activity, and perhaps that should be discussed in general by the task force. Thanks very much.
Thank you. Okay, so public comment general public comment can be closed now, and we can move forward into our cases. And so when you're ready, Cheryl, it looks like we're ready for number 4.
Item number 4, file number 20063, complaint filed by Anonymous against Paul Henderson and the Department of Police Accountability for allegedly violating Administrative Code sections 67.26 for not providing legal justification for redactions and 67.29.5 for not providing the place and issues discussed in the Prop G calendar.
All right, let's make sure. I believe this might be anonymous number 3 who is present. And okay, thank you. And who do we have here for the respondents? Paul Henderson and the Department of Police Accountability.
That would be Sarah Maunder, I believe.
Okay.
Hi, yes, I'm here.
Okay, great. So we will hear from the parties. It does look like it's pretty straightforward. This is a Prop G calendars case. We've seen several of these. But we'll go ahead and we'll hear from the parties first. And so when Cheryl's ready, first from the the petitioner.
Anonymous, are you ready?
I am.
Okay, you have 5 minutes.
Thank you very much. This is anonymous number 3. First of all, the Department of Police Accountability is not a respondent. It's Paul Henderson, and you should keep the caption the way I stated it. Only the department head, as has been discussed many times, has a legal responsibility for maintaining a Prop G calendar. It's not the department itself. So it should just say Paul Henderson. I'm not sure why the complaint, as included in your packet, doesn't actually have my evidence. As you can see, I included the calendar on page P14 as an attachment, but for some reason it wasn't included in this packet. If you looked at that, you would be able to see the various entries that don't indicate the general statement of issues discussed, which is illegal. Then there were some redactions that weren't keyed as well. I also have from another source who has provided me an entire year of Paul Henderson's calendar. Now that's not subject to this complaint, but it's evidence that Paul Henderson never complied with the Prop G calendar law. I have a numerous amount of entries that show that what he discusses, especially with other politicians, is not included in the calendar. If it's like a topical meeting, it'll say what it's doing. But if he's meeting with the mayor's office, it doesn't say what he's doing. If he's meeting with the chief of police, it doesn't say what he's doing. If he's meeting with the police commissioner, it doesn't say what he's doing. And I don't mean a Brown Act public meeting with the police commissioners. I mean privately with police commissioners. And that's not lawful. I don't I don't really have much else to say, but I will introduce the entire 1 year of calendar that someone else has provided to me for Paul Henderson, also into evidence. Though that is not, subject to complaint, it'll just show you kind of the general flavor of what he does. Thank you very much.
Thank you. Okay, Ms. Maunder, you have up to 5 minutes when Cheryl's ready.
Ms. Maunder, are you ready?
Yes.
Go ahead, ma'am.
Thank you. Excuse me. So good evening. There are 2 issues in this complaint. The first one, so I'll address both. The first one is not providing the place and issues discussed in the Prop G calendar. We disagree. In the complaint, there were 19 pages of calendar entries identified for examination. We sent a letter on April 14th detailing how the calendar entries on those pages did actually comply For most of those calendar entries, we believe that the details of what was discussed are evident from the meeting titles. For example, if we refer to the complaint appendix on pages 44, 53, 58, and 65, there were calendar entries for recurring human resources meetings that took place in the director's office. Human resources discussions are confidential, and there's no need to describe specifically what was discussed or provide redaction codes for the information that was never recorded in a calendar because it's private and confidential personnel matters. In the interest of transparency, in our letter, we did provide code sections that detail the confidentiality for those types of meetings. And the second issue is not providing legal justification for redactions. We were treating this as a request. This came in as a part of a very large request for other police misconduct records, and we treated this as a request for Prop G calendar, for the director's Prop G calendar, under Code 67.295, which requires that a calendar be kept or caused to be kept. Here it's a little confusing because we ended up providing Outlook calendar entries instead of essentially creating a new Prop G calendar for purposes of responding. So we did end up redacting some information from the meeting titles that were confidential. We redacted the confidential information from the titles. For example, if an officer's name who is subject to discipline was in the meeting title, we redacted that. And we did not use a redaction code. So in the letter that we sent on April 14th, we hope to correct that by providing the redaction code, which is Penal Code 832.7.5. Thank you, that's all.
All right, thank you. So we can move on to any kind of questions that the members have for the parties. Member Stein, do you have any questions?
I have a couple of questions about this packet, which I'm going to kind of address to the petitioner and respondent. First, for the petitioner, did you submit the attachment separately on that email that we don't have in the packet?
No, I just, that was my original complaint. I don't know why it wasn't included in the packet.
So you separately submitted the document of the attachment?
I'm not sure what you mean by separately.
I mean, because I think in our materials, we say that if things are attachments, don't assume that they will necessarily show up in a packet. But that if you want a certain document to be submitted or to appear in the packet, that you submit that as a document.
I used your form and an email, so that's right. I didn't, in the form, it's just the description, and in the email, I had the PDF. I'm not sure how else I would send a PDF except through email attachment.
But you sent a PDF as to be
Correct.
included in the packet. Okay.
I did, yes.
It wasn't just that you had an email and it just was attached there, but you didn't submit it separately.
I did not send the same PDF twice. Also, I want to be clear. This complaint is from March 2020, before all your new, before any of the new guidelines and stuff. So. Okay,
and then I have a question for the respondent, which is, did you submit any documents to us? You talk about an April 14th letter. I don't see it in my packet. Did you submit any documents?
I did. I sent a letter on April 14th to the main email address.
Oh, wait.
I don't remember what it's SOTS. Yeah.
Okay, I'm just at a little bit of a loss because these things are not seem to be in my packet. And was there anything else you submitted for the respondent? Was there anything else you submitted? Any other documentation, like a formal response?
No, I only submitted one letter, and I believe it was a 2-page letter. Yes, a 2-page letter on April 14th.
Okay. That's kind of all my questions.
All right. I don't have any questions, and I do think that there are missing items. So we sort of have two ways we can do this. One is to delay it and put it over. Although my inclination would be that because I believe that if we can make sure we get the documents and we put it before the task force, the issues are going to be pretty clear. I think that they've already made the request, the responses come in. I don't know what, the decision would be by the task force on the redactions. And this may be that it comes down to whether the issues are properly stated, if they're keeping a proper calendar. I do think that we have jurisdiction, and I do think that we know enough that we know that these are public records. So my leaning would be that we go ahead and send it forth, and with a note that the documents, including the April 14th letter and the PDF to be printed out, would be included in the information that goes before the full task force.
Can I just something quick, Chair Schmidt?
Yes, please.
Ms. Maunder did submit a letter. It is in response to the affirmation letters that I have been sending out per the request of Chair Wolf.
Okay.
And so that's what that was. And you're right. It should have been included, but that's what it is. It is a response to the affirmation letter.
Okay. And was it a denial? I assume it's a denial, but I just want to make sure that this is not a letter where they admitted.
No, it isn't. But I can quickly send it to both of you right now. So if you want to take a quick look at it.
I hate to consider that here because it wasn't given to the public.
I will say that
if you want to send it, that's fine.
She does say, in response to Chair Wolf's letter, the Department of Police Accountability chooses answer C. And I can read that to you, what answer C is.
It's a denial, correct?
Deny one or more allegations below. Please state an additional explanation of which the allegations you deny and supporting evidence and or argument. That is what C is.
Okay.
So I would like to say, I guess I'm asking you, Cheryl, did you receive this PDF with the petitioner's supporting documentation about what was provided and what was redacted? If you can answer that now. But I'll say in the meantime, Dean, that I agree with you. I think we have jurisdiction, it's public records. I think it needs to go forward to the full task force, but pending the inclusion of the supporting documentation from the petitioner.
On March 7, 2020, Anonymous sent a request to open a new complaint. He wanted it to be Anonymous versus Paul Henderson. Allegations 67.29-5 were not reporting the place issues discussed, and 67.26 for no justification with the key redaction in the calendar. That's what he said.
Was there a PDF attached?
Yes, these are calendar entries. Yeah, I don't know why that wasn't included.
Okay, so then I would make a motion to forward this to the full task force with the inclusion of these two documents that we have, but that weren't included here, which are both the respondents' reply and the supporting PDF documentation for the petitioner.
Second.
Hang on. Laura, can you repeat that, please?
Yeah, that I would like to make a motion that we find that
records are public. There is just jurisdiction.
And that we will forward this to the full task force pending the inclusion of the petitioner's supporting documentation, which is that PDF in the email that you have, and the respondent's April 14th letter.
And that's seconded by Chair Schmidt.
Yes, it is.
Want to open this up for public comment?
Yes, please.
Do we have public commenters on the motion?
Yes, please, if nobody else is there.
We have one.
Do we have other public commenters on the motion?
Okay, I think we could go ahead. We have one public commenter.
Oh,
Okay.
actually, I want to comment too. A second one.
Oh, there's a second. Okay, so 1 and 2.
Mr. Warfield, are you ready?
Yes, I am. Just let me know when to start.
Go ahead, sir.
First of all, can you hear me okay? Is there not, everything's clear?
We can hear you.
Okay. So this is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and PO Box 170544, San Francisco, California, 94117-0544. First of all, I'd like to ask and get an answer, if I can, to whether the complainant will get to make public comment. This is one of, and stop me if you have an answer or want to comment. This is one of the concerns that I have with respect to your procedures generally, and I know that you're changing them and reconsidering them in various stages, but perhaps this complainant isn't available next month, though he is today. Maybe there's some other issue that comes up. I would support in general this motion if the complainant agrees that that's okay with the complainant. And I would certainly ask you to solicit that opinion. The second thing I would ask is that there be a clear statement that this stuff be included, what's been missing, promptly or in a timely fashion, or in some way indicate that there's a time issue, and obviously you have your own rules about when the deadline is and so on. I'd hope that that would be amply satisfied. But I do think that it's necessary to really clarify that this needs to be handled expeditiously so that we don't have something similar happening yet again. Thanks very much.
Thank you. We have a second public comment when Cheryl's ready.
Are you ready, sir?
Yes, hi. My name is Sergey Serinov. I'm a resident of San Francisco, taxpayer. And I want to say that this is really a shameful behavior of the Department of Police Accountability. I have read the complaint, and it's an egregious violation of the San Francisco their behavior is an egregious violation of the Sunshine Ordinance. And as a taxpayer for many years in San Francisco, I'm insulted by the fact that as well as the money of other good residents of San Francisco goes to finance really corrupt an incompetent agency of the Department of Police Accountability. Thank you.
Thank you. All right. Let's move to a vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Chair Schmidt, to forward the matter to the task force that the records are public, that there is jurisdiction, pending the inclusion of the petitioner's supporting documentation and the respondent's April 14 letter. Did I get that right, Member Stein?
Yes, you did. And just we already have these in our possession, so it shouldn't take any time at all to include them, right?
No, didn't at all.
Okay.
I'm sorry. I mean, these cases are, and I apologize to the petitioner because these cases are like 3 years old. And I thought I had everything in there, and I clearly didn't. So.
Well, I think in this case we had enough to move it forward, so we're not slowing it down at all, and we're just making sure that it's complete when it goes to the full task force.
Mm-hmm. Okay. We ready? Excuse me. Are we ready for the next item?
Yes.
Item number 5, file number 20064, complaint filed by Anonymous against the Police Commission for allegedly violating Administrative Code Section 6721B by failing to respond to a records request in a timely manner, and 6725B, declaration of a 14-day instead of a 10-day extension.
Okay. For the Police Commission, do we have someone to speak here today?
Yes, can you hear me?
Yes. Could you give us your...
Sergeant Youngblood from the Police Commission.
Okay, great. All right. We have another case from the year 2000, as Cheryl has noted. So let's see if we can move this thing forward. We will start with statements from the petitioner and then the respondent. So first, anonymous number 3.
Thank you very much. Let me know when I may begin.
Okay.
Yeah.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous number 3. I'm actually somewhat confused as to why this case is on the hearing calendar. My understanding, and maybe I don't understand the new process, is there was like a no contest letter from the Police Commission, and so I'm actually not sure why the Police Commission has to be here or why I have to be here. But that whatever happened there, we're here anyway. If the sole issue, and I'll go back and look through now what they've actually produced, because they produced records after the complaint was filed. If I have all the records and there's nothing in there that anything else that I need from them that I need you to order them to produce, I'm just going to drop the complaint. If the only thing that they did is they claim in their no contest letter that they made a mistake by sending the wrong type of extension. Now, if that's true, and I go back and see that there is no missing records, then I will just close the complaint. Everything else is in the letters. I don't know if you need to explain anything. Thank you very much.
All right. Let me then ask you, because it sounds like you're inclined to dismiss this, and if that's the case, we don't necessarily need to go forward. Is there something, Anonymous, that you need to do here? Because otherwise, I'd say we schedule it to go to the task force. Do you want to dismiss this matter?
I can't tell you now, because then I can't undismiss it. So I need to go and review their letter and compare it to all what they've produced. And if the only issue is, as they state, that they sent me the wrong deadline for extension, and they have fully produced the records, then I will close it by email to Ms. Leger whenever I figure that out.
Okay. Ms. Member Stein, should we consider continuing this matter so that Anonymous can do that process? I'm just trying to be efficient here.
Yeah, I mean, I wonder, is that the most efficient, or would it be better to just forward it? You know, we have an affirmation essentially from the police commission that there was a, 67.21B, violation, and sort of a 67.25B, due to whatever circumstances, but they affirm it. And I would almost want to just say that we'll move it forward, but with the note that it's likely to be dropped if,
Okay.
It can be pulled out then, but we don't really slow it down if for some reason all the documents haven't been produced.
I agree with you. Let's then go ahead with it, and let's hear from the respondent, and then we can figure out what. Then we'll talk about if we have any questions, et cetera, et cetera. Thank you. Respondent, when Cheryl's ready, we can hear from you.
Sergeant Earnwood, are you ready?
I'm ready.
Go ahead, sir.
There's really not much more to say. I did forward the letter of no contest. The wrong template was chosen when responding to Anonymous. And it was the 14-day extension instead of the rolling basis. I was waiting for one last commissioner to submit their emails, and they weren't submitted until after that date. So I think you read in my statement that I was actually sick at home that day and did it from home and just chose the wrong template. So that's it.
All right, thank you. I don't think I have any questions. Member Stein, anything for the parties?
Yeah, I just have a question for Anonymous, which is, how long do you think it would take you to confirm that you have everything that you asked for? Because I might like to put a time limit and say something like, we move this forward unless we hear within the next 2 weeks that Anonymous wants to drop it. So I'm just wondering what time period would make sense to you.
2 weeks is just fine. I can definitely figure it out within then. So.
Okay, thank you.
All right. Well, it is a case where we have jurisdiction, and these are public records. There may, the Anonymous number 3 may already be satisfied, but we're not sure yet with the response. It seems like everything is here, so that we probably would just go ahead and schedule this before the full task force and see if it gets resolved before a hearing of that kind. So I'm inclined to make a motion that we find jurisdiction. There are public records, and there are violations which, well, I'm sorry, and recommend a confirmation of violations of 21B and 25B.
I would just want to add that we move it forward unless we hear within the next 2 weeks that the petitioner wants to drop it as well.
That's fine. Let's add that to the motion.
I'm sorry, I didn't hear that, Member Stein.
So something like, we find jurisdiction, that these records are public, and that we move it forward to the full task force unless we hear within the next 2 weeks that the petitioner wants to drop it. Otherwise, we confirm violations of 67.21B and 67.25B as they, since they've been affirmed.
And that is all, that will be all part of my motion, Cheryl.
Okay, second by.
I second it.
Yeah.
So we can move to public comment.
We have public commenters on the motion.
Any public comment on this motion?
The motion is to move it forward unless you're here in 2 weeks' time or within 2 weeks from the complainant that he wants to drop it.
Yeah, that we advance this to the task force.
Okay,
And essentially with the recommendation to find violations of two
Yes.
sections of the Sunshine Ordinance.
Do we
public
have
comment
public
then,
comment?
please?
I'm sorry, Mr. Warfield, did you want to make a quick comment?
Yes, please.
All right. We'll let Mr. Warfield go forward. If we have other public commenters, they will be so named.
Yes.
Okay. Mr. Warfield, are you ready?
Yes,
Go ahead, sir.
thank you. It's Peter Warfield again for Library Users Association. Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this case, and we're not particularly familiar with the details. But there is a whole new procedure in place. It's certainly new to, relatively new. I've had difficulty finding documentation of the procedure when it was in development and or the process of being, I guess, adopted. One of the things that I think is very important is that the law be taken seriously, and that you also stick with and are aware of and act on a larger duty to basically watchdog open government citywide and do the things that you are commanded to do in Section 6730 and beyond. One of the most important things I think that has to happen is that, and it sometimes does, but it's important, and that is to understand, for you to get an understanding of how did this violation occur. There's here a clear violation, and it seems as though people are shrugging it off as some kind of a minor mix-up. And maybe that's in fact what it is, but what causes mix-ups like this? What is the reason for this? Are the forms confusing? Do they look the same? Did somebody reach in and think they were getting Form A and accidentally got Form B? Is there something that needs to be done about that? And then there's also the question of how often does this happen? If the complaint were to go away, there'd basically be no really formal final record of what happened and why it happened. And I think that's important. I'm not saying this is what's going to happen, but conceivably the next time some other mix-up might cause a violation, and another mix-up, and another mix-up. But there wouldn't have been any order of determination to mitigate or eliminate the possibility of this happening again. And there might be something or things that should or could be done, perhaps on your end, but perhaps on the respondent's end, to prevent this sort of thing or similar things from happening again. And that's what I think is very important for you not to lose sight of when you're dealing with these complaints, and that is not only was there or was there not a violation, or even did the complainant think so, but what was the cause of it? How did it happen? And is there a problem there? Thank you very much.
Okay, that's. I think we're ready for a vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein? I think you're on mute.
Sorry, aye.
Okay, great. Thank you. Moved by Chair Schmidt, seconded by Member Stein, to find that these are public records, that there is jurisdiction, and recommend a confirmation of violations of 6721B and 6725B, and to move the matter to the task force.
Did that include everything?
Those are the two violations.
Member Stein, I think.
Yeah, and you said the 2-week pending, right?
Yeah, there was something about the 2 weeks.
Cheryl?
Yeah, I hear you.
Sorry, can you read it one more time?
Moved by Chair Schmidt, seconded by Member Stein, to find that the records are public, there is jurisdiction, to move to the task force and recommend violations of 6721B and 6725B, and let's see, everything's scheduled. And that the petitioner should review the records within the next 2 weeks to see if they have everything. Is that correct?
Well, it's really to move it forward unless we hear within the next 2 weeks that the petitioner wants to drop it. I would put that before you mention, like, otherwise send it to the task force to confirm violations. Because this never needs to go anywhere if it's dropped. So if we hear from the petitioner, move it forward unless we hear from the petitioner within the next 2 weeks that they want to drop it.
All right. I'll read it one more time. Moved by Chair Schmidt, seconded by Member Stein, to move the matter forward, and that within the next 2 weeks, petitioner should inform the task force administrator if they want to drop the case. If not, these records are public, there is jurisdiction, and recommend that this case move to the task force with violations of 6721B and 6725B.
I think that about captures it.
Sounds good.
Okay.
So when you're ready, Cheryl, we'll move to the nominally 2 Severinov cases.
Okay. Let's see. Item number 6, file number 22014, complaint filed by Sergei Zverinov against Lieutenant Lynn Riley and the police department for allegedly violating Administrative Code Section 6721B by failing to respond to a public records request in a timely and or complete manner. Did we want to hear them separately, correct, Chair Schmidt?
Yeah, what I believe that we're sort of bound to hear them separately. I will say that I don't see that there's any difference. There may be 2 different code violations alleged, but that doesn't need to make it into 2 separate cases. And so let's go ahead with 22014, but I will just tell the parties that I don't think there's going to be anything significant to say, which would make it that we would do anything differently with the second case. But let's just start with the first case and resolve that first.
Can I say one thing though?
Yes.
I feel like part of our job should be that if we think it needs to be combined, that it be combined before it goes to the full task force. I would hate for the full task force to have to go through this same process if it's really, one complaint with multiple violations. So I don't.
I'm sorry, go ahead.
Yeah, so I wonder if there's a way to make, to make sure that it gets combined, or that we recommend combining it or something, if that's what we think should happen.
I would put that in the motion.
Okay.
That's fine with me. I think that I think Victor said we can't fuse them in any way, whether it's a combination, a consolidation, a coordination. I don't think we have the power to do anything other than hear them separately. But I'm willing to be convinced otherwise.
I'm saying that we may hear them separately, but I think we should recommend that it be combined before the full task force. And I think Victor said we can't combine them without getting the permission of the complainant or the respondent, but the petitioner in their letter says these should be combined, and the respondent essentially writes the same letter for both cases. So maybe we should ask them as part of our discussion whether they are willing to combine them.
Okay, let's do that.
Victor, my suggestion is to maybe have the party withdraw one of the files and just add all that information into the other file.
All right.
Or add their complaint to the other file.
Let's do that. I'm sorry, Victor. Did I cut you off?
No.
Okay.
It's just it would be easier. The easiest, less stressful method is just to have the complainant withdraw one and add all the information to the other file and make sure all the allegations are in one file and just withdraw the other.
Okay. That's what we're going to do. Mr. Severinov, you've heard our discussion. We would like to combine everything into the same file. I don't know if there was any real reason that this would have become two files. It can easily be part of the same complaint. Are you willing to take everything in 22020 and just put it into 014 and we hear it all together?
Oh, absolutely not. It is a very important matter that these two cases be heard separately. The first case, the first matter in front of you is 22014. It's about the failure to actually disclose the records. But Sunshine Ordinance imposes another very important obligation on their agencies of San Francisco to assist the petitioners in finding the records. And that's a completely different obligation that's dealt with a separate section of Sunshine Ordinance, which is sub C of 67. Well, it's a different subsection. I don't want to take you more of the time. So it's a different and a very important function of the Sunshine Ordinance. So I'd like that to be heard separately, and it's a matter of principle.
But can I just ask Mr. Severinov, are you aware that we can consider violations of both of those sections in the same case? Like, well, we can look at
the public. I think it's very important for the public to identify their duty to assist the and provide a list of all the records, whether they're exempt or not, which is imposed by Section C as a principally important and different matter.
Okay. I don't think that's correct, but if you want to keep them separate, we can keep them separate.
I don't think you and me will ever agree on anything.
We will keep them separate for now. I will say that I don't understand exactly why these became two separate numbers. Even if in the future, even if Mr. Severinov requested that they be two case numbers, I believe that it's a task force's job to instruct him at the outset that no, they would all be combined into one hearing. But since that was not done, let's do 22014, and we may make a recommendation to consolidate, but I think that's all we can do here today. So unless Member Stein has anything else in terms of the handling of the matter, let me just check if someone's here for the police department.
Lieutenant Lynn Riley, San Francisco Police.
Okay, great. Thank you. I think we're ready to go ahead and hear from the parties. We will hear first from the petitioner, Mr. Severinov.
How much do I have?
You have up to 5 minutes.
All right, thank you. All right. So,
excuse me, sir. Are you ready to begin speaking?
okay, I can start.
Go ahead.
Okay. So first, I would like to refer you to pages 102, 103 of the packet for my statement committee on this matter. I also ask you to read my request for records included in the packet. It's on pages 74, 75, in which I requested all the records related to myself, my family, and my residents. So it's a broad request for any records concerning, dealing, mentioning, or referencing us or residents. I would also want to say that the packet for my matter is prepared extremely incompetently, as several documents and submissions are inserted repeatedly. This is a drawback which can make the presentation of this matter very confusing. So let me now comment on the substance. We are an immigrant family in San Francisco. Myself, my wife, and my children have been living in San Francisco for over 20 years. And over this time, we have been harassed, intimidated, insulted with racial slurs, abused, and racially profiled by the Police Department, SFPD. We have filed multiple complaints about SFPD with San Francisco Office of Citizens Complaints originally, and now DPA, Department of Police Accountability, over the years. Some of these interactions were on matters that involved criminal components, and some of them were in any way, such as traffic situation, traffic accidents, and access to public facilities by SFPD. Now, SFPD is a racist, violent, bigoted, anti-immigrant organization inspired by hatred towards minorities and people like us who they think do not fit. This is not my words. It's known that SFPD has many police officers sending messages, and I have included articles about this from Los Angeles Times and Times attached. We have interacted and been insulted and abused by the officers mentioned by those articles. Having been repeatedly victimized by SFPD racists, we want to know what records SFPD keeps on us, and we want to have those records as our rights. Accordingly, I have submitted my broad request for records to SFPD, which is in your packet on February 12, 22. I did this. In a response, SFPD had refused to release any records. Their response reveals that not only they have refused to release records, they haven't done any search. To justify their refusal to do the search for the record, have impermissibly narrowed down the interpretation of my request for records, stating, I quote here, SFPD interprets your request for criminal history records on the individuals. Grammatically, this sentence is incorrect, but that's what SFPD is. Uneducated, illiterate, racist, violent organization. SFPD has no right to narrow my request, in which I sent all records, broadly dealing with me and my wife and my family and my residents. No search has been done by SFPD. SFPD has also an obligation to keep reductions and withholding to a minimum. So their broad reference to a section of a criminal cannot serve as a justification to withhold any other records. Now, finally, San Francisco Sunshine Ordinance presumes that all records are public. So SFPD is obligated to make the search and then make a determination, but they have not really made any search as their reveals. So their failure to do a search and analyze the records is the most egregious violation of the law. Finally, what I want to say is that SFPD also has no right to refer me to a different procedure to request their records. My request to SFPD for all public records is valid, and it's not an excuse for them. It's an invalid excuse for them to refer me to a different procedure. The last thing I want to say that on page 153 of the pack, I provide an example of existing public record which should have been disclosed by SFPD but had not been disclosed. This is a record created by SFPD officer DACA, number 303, and this is a record which I want you to carefully examine because it's a record which is the title Office of the Citizen Complaint, but it's a form that belongs to it's a blank form filled out by Officer Apodaca from the SFPD, and that's a public, that's in SFPD. and it has been released to me by DPA. Thank you.
Thank you. All right, respondent, you have up to 5 minutes when Cheryl's ready. Lieutenant Riley.
Lieutenant Riley, are you ready to begin?
Yes, ma'am.
Go ahead.
The San Francisco Police Department is in receipt of both complaints filed by Sergei Silvanov with the Sunshine Ordinance Task Force, alleging that San Francisco Police violated Administrative Code Sunshine Ordinance Section 67.1 by failing to respond to a public records request in a timely and/or complete manner. The complaint was received on March 10th, 10/22. The FPD received Mr. Saranov's immediate disclosure request on February 15th, and we provided a timely response February 16th. SFPD stands by its initial response. The requester seeks any records, including arrest records, regarding the listed persons, referenced individuals. SFPD interprets this request for criminal history records. That information is protected from public disclosure pursuant to the Penal Code 11-105. Furthermore, SFPD supplemented its response with a letter dated March 17th, providing instructions on how to obtain his own criminal history records through the ID section of the SFPD. Please note this process is not through public records request. As for any records, including arrest records on the other referenced individuals referenced in the public records request, SFPD interprets this request also for criminal history records. That information is protected from public disclosure pursuant to the Penal Code 11-105. And we submitted some supportive documents to the Sunshine Ordinance Task Force for consideration. I would just like to add that we assist numerous people many times a day. We redirect people. This is not a one-stop shop, so to speak. It's SFPD. So the public requests come through legal division, and we have many other entities which we can assist this individual with. Thank you.
All right, thank you. So we move to questioning of the parties. Member Stein, do you have any questions to start with?
Yeah, I have a few questions for the respondent. My first is, why did you assume that the petitioner was only asking for criminal records?
Hi, Member Stein. You know, I did not personally look at all of these complaints initially in February, the request in February. But after reviewing the documentation and the list of persons attached to this request, absolutely any information that would be obtained for all these persons could be done through the ID Bureau. So you're asking me, why did I interpret that as criminal records? It's a litany of things that is, or people that are listed on this request, and all their information which can't be released. Yeah, so based on that, police reports, etc., I don't know, really get buried in paperwork and we're not able to, have a conversation with somebody. Instead, we have complaints, but that's where we are. So,
Okay, anything else on that question?
No.
So you're basically saying that you assumed it was that they only were talking about criminal records because it named individuals? Because the request named individuals?
No, I didn't say that.
okay, again, just in one sentence, why did you assume it was that they were only asking about criminal records?
I don't have an answer for you, Member Stein.
Okay, it wasn't clear to me, so okay. And then, was any search process done before responding that, you didn't have any, you couldn't give the records? Was any search process done?
You might have to go back through the software platform and see what was conducted in searches to answer that effectively, and I don't have that in front of me.
Is it possible that the SFPD could have, for instance, email correspondence, incident reports, permit applications, or other kinds of records besides criminal records on any of the individuals named? I mean, on anyone?
Yes, it's possible.
Okay. And then I have just one question for the petitioner, but I think I know the answer. I just want to confirm, this is a complaint, you're just complaining here against the SFPD, right? Not the Department of Police Accountability. This is not against DPA.
Yeah, I'm sorry about my English. I'm an immigrant. Yes. I'm complaining here about SFPD, racist, anti-immigrant, bigoted organization represented by racists.
My only question is, this is just a complaint against the SFPD, not the PDA. The police,
I'm
the
sorry.
PDA.
Maybe it's not clear.
Yeah, you mentioned it somewhere in the petition, so I just wanted to make sure. All right, those were all my questions.
All right. I want to first ask the petitioner. The police department told you could ask for incident reports from the CISD. Have you followed that recommendation?
No, and I do not intend to.
Okay. How about you answer my question, sir. I need to ask you another question. The police department told you to ask the DEM for any kind of 911 calls. Have you done that?
This is illegal, which actually is not a matter of this consideration. This is a public record, and all the police department records are public.
It sounds like you haven't done that. That's fine. I just wanted to see if you've pursued the recommendations that they've made to you.
It's not an recommendation, sir.
Sir, I don't have any more questions for you. You answered my questions. It's my turn. Now, I want to ask Lieutenant Riley a couple questions. In your documentation, you mentioned that the request made by Mr. Severinov, it was interpreted as a kind of request which only asks for criminal history information. My question to you is, who made the decision to make that interpretation?
So that would be a legal assistant interpreting the request. And are you talking operationally, or do you just want me to end with that answer?
Well, to make an interpretation like that, it seems like that's a decision that someone made. How is that done?
So we received numerous requests, and some of them are we're able to answer, pull up files out to different units within the department. In this case, asking for the detentions and arrests, I think through this list of persons and CADs related to this list submitted for request originally by the requester, since it contained those words, detentions, arrests, etc., I think this entire request is related to, it was interpreted at the time to be related to criminal records based on kind of the core of what this is asking. Oftentimes
if you've seen other cases where there's an interpretation done of what the wording actually is in the request that's made.
I think all of our requests, there's definitely times where we're able to respond with information on portions of the request, and then other portions of the request have to be referred to custodian of records or whatever that entity is or whatever that portion of the request is. I think in this case, based on the numerics, sequential numerics of the request and some of the wording that was used, it was interpreted at the time to be of the nature of criminal records. And that is why the response letter reads as such.
Okay, my second question to you is, if that interpretation is done to say that this has to do with criminal records, there's an exemption claimed, Penal Code 11105. Would all criminal records that could be available that would be responsive, could those only come from the state summary criminal history information that is described in that penal code provision? Or do you have other criminal records that wouldn't be from the state summary at the police department?
Mr. Chair, I'm not sure I understand your question.
Okay, I'll try to answer it. Yeah, I'll try to ask it a little more clearly. I'm looking at Penal Code 11105, which would apply to the state summary of criminal history information, which is maintained by the Attorney General's office, I believe. And are there any criminal records that could be available as requested and interpreted that would not come from that state summary that are maintained by the police department?
I don't know.
Okay. Thank you. I appreciate your honesty on that. All right. I don't have any other questions, Member Stein, partly because I concede that my recommendation is that this should go forward to some extent to the task force.
I think I'm on the same page with you. When I read this request, the first thing I see is just an interest in any information or any communication or any record dealing with these four individuals. It gets more specific later on as wanting specific information about detentions and arrests. But what I see is sort of a general request for information about all the individuals, and it's clear that no search was done to see if there was any records that pertain to that, like within kind of easy reach, not even there could have been a search done, say, from the IT department of police records that mention these names. I think that's a pretty easy search to do, but it wasn't done. I am also concerned about the narrowing of the request. When it's clearly meant to be more broad, or it seems clear to me that it's meant to be more broad, and it's not the job of the agency to decide to narrow a request, essentially, unless they do so in conversation with the requester. So I would also be inclined to, suggest that the SFPD needs to do a search for any and all records that may be under their purview, not just criminal records, which may be exempted. So I think it also probably should go before the full task force.
Yeah, I have a problem with. We don't have a motion quite yet, but we're pretty close. I have a problem with the whole idea that they would interpret, like you need to somehow take the actual words and say, well, what they mean is actually something different, because the words themselves are the request. So this interpret part of things, I don't get it. And I don't know if I've seen, people doing that elsewhere. So that doesn't work for me. And also the state provision, the penal code provision, I'm not convinced that would really even apply to a lot of things, because it's a very specific provision. So I don't know if I've seen that cited before, but I don't know if that would really, if it were broader, yeah, it could be an exemption, but I don't know if that exemption applies.
So only other thing I want to say is that even though the petitioner doesn't mention it in this particular complaint, there's obviously, I think, the potential to look at a violation of 67.21C, failure to help identify the form, quantity, and nature of available records. That was never done because no search was performed, and also the request was narrowed. So I would also add that in to this, which may also help us, consider it as one file later, because I think there's also was a failure to communicate with the petitioner in the decision to narrow the request or to identify what records might be out there.
Okay, so let's, I'm going to make a motion that we send this to the full task force. There are public records involved. We have jurisdiction, and we ask that the task force decide if there's a violation of 67.21B, and also, in this case, also decide 67.21C. And because that can be also looked at and decided by the task force in this matter. That's my motion.
I second that.
Okay, we can move to public comment when you're ready, Cheryl.
Do we have public commenters?
Anonymous number 3.
Okay.
Peter Warfield.
Okay, we have 2. Let's start with anonymous number 3, Cheryl.
Anonymous, are you ready to begin?
I am.
Go ahead, sir.
Thank you very much. This is anonymous number 3. I think your recommendation is right. I would suggest you add some things. What the police department did here, I don't even understand how they thought it was legal. You get a records request, you have to conduct a search, because only once you have actually searched and found the actual records, then you can review them to make sure they are exempt under the exemption you want to cite. You can't just theorize about what the records could be and give an argument. And that's why I've asked that you add the recommended violations of 6726 and 6727. The issue here where they claim a certain database is an exemption for all information related to criminal history, you may remember that the sheriff's department did this to me a while back at the full SOTF, and you found a violation then too. These exemptions have specific databases and specific locations of data, and only that data is exempt. And unless they can find a better exemption, they have to produce all the rest of the data, even if it's related to crime, just as a general feature. And so that's the 6727 that I think the full task force should look at. And 6726 about the fact that I think member Stein raised it, and I think it's very important. Like, emails are police department public records. You have to search for them. And they may be easy to search for, but that's not the requirement. Whether they're easy or not, you still have to search through them. And that means they're non-minimally withholding, right? Because they have claimed this citation to this something to do with the Attorney General database, and that clearly cannot cover just emails that might be communicated. Unless they reviewed it, each document, and made sure they minimally withheld each document, they haven't complied with the Sunshine Ordinance. And so I agree with this motion. I'd urge you to ask that the full task force consider 6726 and 6727 to make sure that they give every non-exempt portion of a responsive record to this complainant. Thank you very much.
Thank you. All right, we have one more public commenter on this matter. When you're ready, Cheryl.
Mr. Warfield, are you ready?
Yes, just tell me when. And we've got 3 minutes. Is that right?
Yes.
Thank you. Tell me when you're ready. Yeah.
Go ahead. Go ahead.
Beg your pardon?
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this case, and we're not familiar with the details, but we have been listening to the entire session of the hearing. First of all, I want to thank the chair and member Stein in particular for pressing on a number of questions that have to do with a very important issue, and that is, how did this happen? Not just what happened. You are pretty clear about what happened, but how did it happen, why did it happen, and who made the decision? I believe Member Stein tried several times to find out who made the decision. And I'm sorry I can't cite chapter and verse, but it's my understanding that when there's a refusal of some kind, there has to be a person who has the responsibility and is named as the person who has made the decision to deny something. So I'm not sure whether that's a complete denial or a partial denial, but I think that the responsible party should be named. And I think the task force ought to find out more details about what happened and why before it lets this whole thing go. I certainly agree with the motion, and in particular with the comment that Anonymous made. I heard a portion where the respondent said that these certain records, I believe I heard her say clearly these were not public records. Well, excuse me, that's a fundamental misunderstanding. Everything in their possession as a public agency is a public document. The only question is, are those public documents disclosable in full or disclosable in part, and so on. One of the things that I would like to mention here is that I think your procedures ought to be improved as follows and are lacking as follows. And that is, you do not have direct testimony from the people who actually did the actions that are in violation. And I think that firsthand evidence is absolutely critical in understanding what they did and why they did it. Was it a policy of the department? Was it a command from on high? Was it a mistake or a misinterpretation? What actually happened? And that is why I think you need to insist on not just authorizing.
Thank you.
Direct evidence. Thank you.
Yes. All right. Let's go ahead with a vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to forward the matter to the task force, that the records are public, that there is jurisdiction, and to ask the task force to decide if there are violations of 6721B and 6721C.
So we can move to the next item.
Hang on a second, guys. I get my paperwork here. Okay. Item number 7, file number 22020, complaint filed by Sergei Zverenov against the police department for allegedly violating Administrative Code Section 6721C by failing to respond to a public records request in a timely and or complete manner.
All right. I have a question to Victor, and it comes out of this. I believe that based on the suggestion of Member Stein, we considered and we forwarded the question of a 21C violation to the task force. Therefore, this complaint is duplicative of the prior complaint. Now, if we have a duplicative complaint, do we need to go ahead and hear it? How can that be dealt with without having to go through the exact same thing we just went through again?
We're talking about the motion that you just made on the item.
Yeah, we just resolved 22014, and we sent, based on exactly the same facts, the same, everything as we would be seeing in 22020. We forwarded to the task force the questions of 21B and 21C, where 22020 asks for a finding of a 21C violation. And so is this not now completely duplicative of the last case we heard? I believe it is.
If you believe it is, I would just send it forward with a recommendation that it's duplicative and that the matter be tabled or filed, as it is a duplicate file.
Okay.
But only the task force can actually close it. The full task force can actually close it. But you can send it forward with a recommendation to close it as it's duplicative of the previous file.
Okay.
Well, there are different record requests made on the different complaints.
If we want to do that, Victor, do we still need to have a hearing here today?
You should take comments from the parties and then send it forward with a recommendation that it is duplicative. We should give them the opportunity to tell us why they believe it's not.
Okay, so yeah, I will go ahead and hear from the parties, and they can tell us if they think there's something about this that was not also already dealt with in the last case. So we know the parties are here. When Cheryl's ready, we'll hear from Mr. Severinov.
Yeah, okay, so this is not a duplicative request, and you cannot make determination before you hear this request. Only then you can say it's duplicative or not. Second, it's not a duplicative request because it's based, it's not duplicative complaint, sorry, because it's based on a different request, which is part of the original, of the first complaint that you have heard, made after I have received a rejection, a refusal from SS. I specifically submitted a new request based on section 6721C, in which I didn't request a disclosure, I requested an assistance. Different request for assistance based on 6721C. And that new request for assistance was then refused by a different action of SFPD. So we're talking about different actions as FPD, different requests made by me, different responses by Lynn Riley.
Okay, thank you. We can hear now from Lieutenant Riley on this, when Cheryl's ready.
Lieutenant Riley, are you ready to begin?
Yes, ma'am.
Go ahead.
As Mr. Chair and Committee Member Stein pointed out, this is a duplicative letter, so I will not read the letter again. submitted.
Thank you. Okay, Member Stein, do you have any questions for the parties?
Is that for complete testimony?
Yeah, she said submitted.
Okay.
Thank you for your brevity, Lieutenant. Member Stein.
I have one question for the petitioner, which is that I'm looking at both of these requests. I understand that in one you're asking for assistance, but in terms of the information that you are requesting, what is the new element? Are there any new pieces of information that you're asking for in your list of the information that you would like? I see 25 points on the first request, I believe, and 25 points on the second request, and they all seem identical to me, but can you tell me if there's something new in any of them?
No, they're not identical because, in particular, actually in the request for assistance, which was submitted later, around in March, I have requested, put a different request for information about my residence, surveillance of this residence, the presence of SFPD at this residence, and their any contact and any times they were called and or interacted with people in this residence.
Oh, so is this like points? Oh, points 21, 22,
Yeah.
23. Those are the ones asking about the residence address, correct?
Yes.
Okay. So there are a few different differentiated points in this list of 25 points.
There were changes made?
Yeah, there were a few changes made. So I guess, you know, in that case, you know, I might say, you know, we can treat it as a separate request and recommend finding the same, you know, recommend finding another violation of the same piece, which is, where did that go? 6721C, right?
So in this case, you're recommending that we would
well, there are a few different pieces of information that were asked for.
Okay.
And not provided. I mean, I think really, actually, again, you could just say recommendation of violation of 6721B and C, even though the petitioner is only asking for one of those in this case. But again, you know, there was really no search performed.
Yes.
There was no assistance provided. So I mean,
Yeah.
I guess if there are some new pieces of information asked for, we can, you know, we can treat it separately. They're extremely similar. I think they could easily be combined. It's going to require that everybody have to, you know, be there for double the time, but we can treat it as separate requests.
Okay, so let's go ahead. I'm going to move that we find all the things that we can find: public records, jurisdiction, and we forward this to the task force to decide whether there's a violation of 67.21B and 67.21C, and that we have these cases always heard together, these two.
Yeah, I would second that.
Okay, we can open that for public comment. Anyone for public comment on that matter?
Anonymous number 3.
Okay, anonymous number 3.
Yes, please.
We have 2 public commenters. Whenever you're ready, Cheryl.
Anonymous, are you ready to begin?
I am.
Go ahead.
Thank you very much. Synonymous number 3. I agree with the motion. I'd just like to point out something about identical requests. I and other people on the internet who make requests based off my templates, we often make the same word request, but on, say, 2 different weeks or 2 different months, or even, multiple days apart. And they are not the same request if they are made at different times, because the records that are responsive to them can be different, right? So you can ask for, give me everything related to me, and they may have now, once you made a request, and they do this, they'll now talk about you internally. And so when you make the second request, you can get information about the first request. So even if you use the same words, but at 2 different times, the responsive records to each request could be different. And that's all. Thank you.
Thank you. Okay, Cheryl, when you're ready, we have a second public commenter.
Mr. Warfield, you ready?
Yes, I am. Just let me know when to start.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. The duplicative issue and the rules concerning it have for a long time been a really serious problem, and have left open to the task force a huge and sometimes acknowledgedly erroneous ability to basically not really deal as much as people would like them to deal with what people consider to be separate issues. Certainly Anonymous has mentioned an instance. There was a particular instance that I experienced in which there was no hearing provided because of a claim that something we had provided was duplicative. And finally, when we were completely flummoxed about where that came from and how that happened, finally, when there was a change of leadership, it turned out that the person who was most advocating that there not be a hearing because of its duplicativeness, the new leader said, "Let's just have a hearing. And are you still objecting because of duplicativeness?" And very quietly, and with pretty much a single word, the proponent of duplicativeness said no. And that's because that complaint had never gone to hearing. The supposedly duplicative thing was not ultimately duplicative of anything, because there had been a hearing that had been a complaint that had been withdrawn. With respect to what I said previously, you have not had in your hearing testimony from either side about this issue of assistance, and you haven't had public comment on primarily the issue of what was discussed previously, because neither party specifically addressed the whole question. Do I have 30 seconds or what?
30 seconds, that's what I'm saying.
Thank you. It's breaking up a little. And so you still don't know who made this decision. It could have been somebody completely different. You don't know how or why. Maybe it's a department policy. Maybe it was a direct instruction, unlawfully instruction from somebody higher up. You need to find out how it happens that a similar decision, which could have been made completely at a different time by a different person, how that happened. That's important. So I certainly think you should keep these separate and go forward with your motion. Thank you.
Okay, thank you. We're ready for a vote.
Do I have time for a comment also?
You can't make a public comment on this matter. Your case is going forward, but we're going to have a vote now.
But the packet that's submitted to
I said, Mr. Smirnov, it's not your turn. Okay, you've had your turn.
I didn't have my turn. I wasn't given time.
Cheryl, when you're ready, we can have a vote.
All right. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Stein. I think you're on mute.
Sorry, this computer is acting up. Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, that the records are public, that there is jurisdiction, and to forward the matter to the task force to decide whether there is a violation of 6721B and 6721C, and have both cases 22020 and 22014 heard together.
But by heard together, we just mean heard concurrently, not combined.
Heard concurrently. All right, I'll say that.
Now, what about the matter of the packet which was not compiled correctly?
Mr. Smirnov, I'm just going to note that you basically all of this has been moved forward for further hearings before the task force, and so everything is moving forward, and all these matters will be considered later on.
But the packet isn't complete. The packet.
Well,
thank you.
I believe you have opportunity to continue. Can I just say you have the opportunity to add to the packet? You can submit additional materials between now and the full task force hearing. Anything that you believe needs to be in there, you should submit it.
Assistant Ms. Ledger didn't put it in.
Thank you. We need to move to our next case. Cheryl, the Bajanski case is next.
Item number 8, file number 22022. Complaint filed by Cillian Bajanski against the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 6725 and Government Code Section 6253C by failing to respond to an immediate disclosure request in a timely and or complete manner.
Okay, is Mr. Bajanski here?
Yes, I'm here.
Okay, and is someone here for the Office of the Treasurer and Tax Collector?
Yes, Deborah Liu is appearing on behalf of the Office of the Treasurer and Tax Collector.
Thank you. So we will start with opening statements of each of the parties for up to 5 minutes. And we'll start with Mr. Bajanski when Cheryl's ready.
Mr. Bajanski, are you ready to begin speaking?
Yes, I'm ready.
Go ahead, sir.
I think the complaint is quite simple. On February 19, 2022, I submit a public request for a release of documents to the Treasurer and Tax Collector. Under California Government Code 6253C, I know that I will receive all the documents within this request within a maximum of 24 days. That means a deadline of March 13, 2022, Monday. Instead, on February 25, 2022, I received a message from the Treasurer and Tax Collector that due to privacy issue, some of the information will be redacted, and they are invoking a rule of reason to limit the amount of time that the staff may devote to responding to this request. San Francisco Code Administration 6725D. To this day, this request is still open, and I don't know how much information I have received from all available. So I think the 6253C was violated by the Treasurer and Tax Collector. Thank you.
Thank you. Okay, now we can hear from the respondent when Cheryl's ready.
I'm sorry, who's speaking for the respondent?
Deborah Liu.
Yes, are you ready? I'm ready. Deborah Liu, appearing on behalf of Treasurer and Tax Collector.
Yeah, just a second. I want to get the timer ready. Liu. Okay. Are you ready, ma'am?
I am.
Go ahead.
Thank you. The only real reason, I think, is whether the city has exercised the rule of reason in this situation in proper manner. First, the request is not an IDR. nonetheless, we sent a statement notifying the petitioner that this would be handled as a PRA request. We timely indicated that there were voluminous responsive documents and that we were invoking the rule of reason. The response generally sets forth the process that we use to review and redact the documents, that we have been producing documents as soon as possible on a rolling basis. So pursuant to the 2021 Attorneys of San Francisco Good Government Guide at page 103, that states, in rare circumstances, responding to a public record request may be so burdensome and time-consuming that the demands placed on the department to respond within the required time frame would unreasonably impinge on the department's ability to perform its other duties. The same is true for a series of requests from the same requester that cumulatively impose extreme burdens on the department. So in those rare cases, the city may invoke the rule of reason. And so that's what we did. The lawsuit that we mentioned in the response to the complaint is relevant because it gives context to why we invoked the rule of reason. TTX represents the Office of Short-Term Rentals in a lawsuit filed against the petitioner for a violation of the Short-Term Rental Ordinance. Here, Bizansky serially propounded 11 PRA requests and also 8 sets of civil discovery requests. We have upcoming mediation, motions, trial dates. There are voluminous documents. And we also described in our response that an inordinate amount of time has been cumulatively spent processing the PRA responses. I do have on telephone the legal assistant who assisted in processing the PRAs. We have offered to waive the redactions of private information, which we are obligated to redact, and the petitioner refused to explicitly agree to do this. So we do have to go through and redact the personal information. We believe that we have properly invoked the rule of reason. We have spent over 40 hours after April 1st, and we still have more than 325 of the 550 documents to review 40 hours later. So the board should also be aware that this has been extremely burdensome because we are short a legal assistant who recently retired and also short an attorney. We have one of 3 that was out for a few weeks and another one is currently out for medical leave. So we're doing the best we can with all the other duties that we're juggling. And by the way, we are hiring another legal assistant I've already reviewed, and so hopefully we'll fill out that space of the new legal assistant shortly.
Thank you. All right. It's time if we have questions for the parties, although it does look fairly straightforward what we're looking at here. I would agree with Ms. Liu that, yeah, this is basically about the rule of reason. Member Stein, any questions for the parties?
I have a question for the petitioner, which is, are you willing to be provided with documents in which your personal contact information has not been redacted?
Is that a yes or no question? Because
yeah, it's really a yes or no question. Do they have to redact your personal information or do they not have to redact it?
No, as long as they deliver it on time, I don't care. But it wasn't delivered on time. What I'm caring about is to be delivered within 24 days, as is said by the government code.
Okay, and then, let's see. So you found 500 records. That's the sum total of your records for the respondent.
I don't know. I mean,
yeah, this is a question for the respondent. Sorry, thank you. Sure. Thank you to the petitioner. That was my question to you. Were these records released only to the requester? Or as you're releasing these rolling records, were they released only to the requester, or are they somehow been also made available to the public, the rest of the public?
Catherine, can you help?
Yes, this is Catherine Sachs. I'm a legal assistant with the tax collector's office. And these particular records were released only to the requester because of the ongoing litigation involved.
Okay, and so you've heard him now say that he doesn't need you to redact his personal information. So going forward, can you speed it up somewhat by not feeling the necessity to redact that? Since these are
Yes, that would definitely help speed things up if we did not have to redact his email and telephone number.
Okay, because I think he's made it clear that you don't, so that I'm hoping that the records can come through more quickly. I think those were my questions.
Okay, just to the respondent, could you tell me who made the decision in your office on this matter to invoke the rule of reason?
Attorney-client privilege.
Okay, so okay, was there a person in your office who's not an attorney who made the decision? And if you're saying that an attorney made the decision, that's fine. You don't have to say who it was. But it sounds like the decision may have been made by someone in your office, even if it was in consultation with legal counsel. And so that's what I'm asking you, is who made that determination?
An attorney made the decision.
Okay, thank you. Do you have legal counsel within your office, or would that be someone at, I'll just stick with that question. Is that an attorney who is within the tax collector's office, or is it someone else outside that office? So you made, whoever made, okay, so a decision was made by an attorney.
It was someone within TTS.
Oh, within TTS, okay. And
It
sounds like so you wouldn't know then what their reasoning process was, because that's not someone who's present here today, correct?
You're trying to find out who the lawyer is who made the decision?
No, I don't need to know that. How many attorneys do you have working within the Treasury office?
One to my knowledge.
One to your knowledge. Okay, so that's the counsel within the office. All right. Okay, I don't have any further questions. So, Member Stein, what do you think we ought to do with this?
I have to tell you, I'm not sure at the moment. I do not see this as an IDR, a proper IDR, because it was voluminous and it's happening when there's a legal matter pending. And so I don't think it's something that, it's a simple request that could easily have been fulfilled in the framework of an IDR. That said, it does seem like it was slowed down by this idea that, the personal information of the requester had to be redacted, which doesn't make sense to me in this context. Good governance manual aside, you're providing it to that person, so it obviously got slowed down. I'm hoping that going forward, this information can be processed and released more quickly now that piece should be out of the way. But, I guess you could say it wasn't fulfilled in a timely or complete manner. But I do think the office seems to be making a an effort to release documents and to do it. Nothing in the Sunshine Ordinance says you have to throw all your manpower at a request immediately to get it out there. But I also don't, I know we've had this talk before, but I don't necessarily think rule of reason is a good defense here. But I think the Sunshine Ordinance itself allows for rolling release of voluminous records, and this was just done very slowly. So I don't know. That's kind of what I'm grappling with. What is the violation? Is that it was too slow? Maybe it just hasn't been released in a timely manner because this decision was made to redact all this personal information.
Yeah, I generally see this about the same as that, is that it seems like a rolling release is not the worst way to go here because of the circumstances that they're under.
Mm-hmm.
Although I don't know if we can necessarily judge today whether the rolling release that's occurred here is valid, because we can't make any decisions. Frankly, we could just we could decide whether we're going to forward this, whether it's whether these are public documents, whether we have jurisdiction. I also agree it probably was, well, I don't know if we can't necessarily decide whether it was a proper IDR, but I would tend to think if it wasn't really an IDR material. But I think that ultimately, I don't know if there's anything we can really do here today other than I'm going to make a motion that we forward this matter to the task force. They're public documents. We have jurisdiction, and it's to decide whether there's a violation of 67.21 and also Government Code 6253C. Do you want me to add anything to that? That's probably a good type motion.
Yeah, I mean, the full task force can obviously consider if they want to look at it as an IDR, but I don't think there's a very strong case for that. So I would also say, yeah, as long as we're recommending, I mean, our recommendation would be to focus on 6721 and 6253C. I will second the motion.
Okay. So we can hear public comment on that motion when you're ready, Cheryl.
Do you have public commenters on the motion?
Anonymous number 3.
Anonymous number 3. Anyone else? Okay, let's go ahead. Anonymous number 3, public comment.
You ready,
Please
sir?
let me know when. Thank you very much.
Go ahead.
All right. Thank you. This is anonymous number 3. I'd agree with the motion. I think Member Schmidt or Chair Schmidt has pointed this out in other rule of reason complaints or complaints where the defense is the rule of reason. There's a specific court case that defines the rule of reason, and they have to actually follow it. And the fact that it would be impossible to do their other work in order to meet the 24-day deadline would be a valid rule of reason argument. But they made another argument, which I think is very dangerous. Well, this person, there's some ongoing lawsuit with this person, and that somehow allows them to slow down records given to this person. That's not true. Lawsuits and sunshine requests are completely separate. You do not lose your right to make sunshine requests in any way. It's not reduced in any way. All the same records are public, and the disclosable nature of them does not change because it's also a pending lawsuit. If there's something non-disclosable because it's a pending lawsuit, that's a different issue than we're going to slow down your records request because you're an opponent, a legal opponent of the city. You don't lose your sunshine rights or have them essentially thwarted in order to prevent you from prevailing in that lawsuit because they want to slow down your records response. That's all I have to say. Thank you.
Thank you. All right, I think we're.
May I respond?
Oh,
I have comment, please. Public comment here.
We have another,
Warfield, one
we
thing
have
at a
another
time.
public commenter, but we can't have any public comment by the parties themselves. But yeah, when Cheryl's ready, we do have a second public commenter.
Mr. Warfield, are you ready?
Yes, I am. Just let me know when to start.
Go ahead.
Okay, it's hear me okay?
Yes.
I heard a white noise. This is Peter Warfield, Executive Director of Library Users Association. I hope you'll start my time 15 seconds or so more later. Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. I certainly think that the rule of reason is something that is a real wrench, so to speak, in the procedure of making information requests. Obviously, somebody can't walk in and say, show me all your records. But the only restrictions on requests, as far as I am concerned, is what's described as getting information about information, which is what we heard in a previous case here tonight. And that's specifically aimed at enabling somebody to make a more focused request than might otherwise be possible. It's presumably something that's desired by the respondent, but it's certainly, speaking as somebody who makes information requests, certainly something that the requester might want and likely wants. I mean, I may have a fairly simple request. I don't want to be drowned in stuff, and actually that has happened at times. Let's drown them in stuff that maybe wasn't even asked for, that's superfluous or additional, and so on. So personally, I want to make well-focused requests as to who is being requested from, what the time period is, and so on. The rule of reason to talk about the sum of a person's requests, I think, is very dangerous, because it sets up a potential that one request, even inadvertently requesting what seems to be a lot of records, can presumably suddenly cancel out, so to speak, a reasonable effort on the part of the other requests, which might have been perfectly reasonable. And so I think that that's a very dangerous formulation that I'm hearing from presumably Good Government Guide, page 103. I can see if an individual request, perhaps inadvertently or not, seems to be unreasonable, but it seems to me they should be judged independently. A legitimate request is a legitimate request, and if you have 10 legitimate ones and one that the department decides is not legitimate, that one shouldn't be able to disqualify all the other ones from getting the attention that they reasonably deserve. So I think you need to be very careful about this rule of reason, quote unquote. And if there is a court decision, as Anonymous has stated, I certainly think that would be worth reviewing and looking into and advising the full task force to do as well. Thanks very much.
All right, thank you. That's those were our public commenters, and so in order to get this moving forward, let's go ahead with a vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein, to find that the records are public, there is jurisdiction, and to forward the matter to the task force, and to decide if there are violations of 6721 and California Public Records Act 6253C.
Okay, next case.
Item number 9, file number 22015, complaint filed by Anonymous against the Police Department for allegedly violating Administrative Code sections 6721, 6725D, 67.69-7A, and 67.34 by failing to respond to an immediate disclosure request in a timely and or complete manner, failing to provide records on a rolling basis, failing to preserve and maintain records, and willfully violating the Sunshine Ordinance.
Okay, Anonymous, you're up first.
All right. Thank you very much. Let me know when I'm
Hang
ready.
on, don't anybody speak until I get the timer going. Anonymous, you ready? Anonymous?
Hello? Hello? Can you hear me?
Yes.
Yeah, he's ready.
Okay.
Go ahead, sir.
All right. Thank you very much. This case, I don't know why it has the wrong respondents. It is Director Matt Dorsey, Chief William Scott, and SFPD, and does need to be named properly in the agenda when it goes to the full task force. In this case, in December 2021, hey, we're finally in the current present world. In December 2021, I made a request for text messages and other, related things from the Director of Communications for SFPD. This is because there's this discovery of these texts between the mayor's office and SFPD, where they coordinate how to do, how to make themselves look good about, crimes and policies and responses to those crimes. And they had talked about how they deleted those records, and we found evidence of them deleting that records, and that's why I made this request. As you know, in the Good Government Guide, you are required to preserve records once you receive a request. And they just didn't respond to my request for months, and I have no idea what they did. I have no idea how the person who's in charge of communications wouldn't respond to a records request. This is his entire job, is to make sure that the public has information about what the SFPD does. I don't really have anything else to say. I made the request in December. I filed a complaint in February 2022. They violated all sorts of laws by not responding. That's it. Thank you.
All right, thank you. And for Matt Dorsey and or the police department, would that be Lieutenant Riley, who's here today?
Yes, Mr. Chair, it's Lieutenant Riley.
Okay, and just take note that the petitioner did make it clear that Matt Dorsey is the named respondent here. But when Cheryl's ready, it's time for a response from you. Up to 5 minutes, but you don't need to take all 5 minutes.
Lieutenant Riley, are you ready to begin?
Yes, I am.
Go ahead, ma'am.
Thank you, Cheryl. The San Francisco Police Department is in receipt of the complaint filed by Anonymous versus Director Matt Dorsey and the Police Department for allegedly violating Administrative Code sections with Sunshine Ordinance Task Force, alleging that we violated Administrative Code sections 67.21, 67.25D, 67.69, 7A, and 67.34 by failing to provide records on a rolling basis, failing to preserve and maintain records, and willfully violating the Sunshine Ordinance. The complaint was received on March 11th, 2022. On December 24th, 2021, SFPD did receive public records request referencing number P as in Paul 063318-022322 from Anonymous. On March 17th, SFPD responded to the request by providing responsive documents listed below, which is in effect 4 images. These images were uploaded to the GovQA portal to provide immediate access to the requester, Anonymous. The SFPD was unable to immediately produce records due to staffing shortages, which caused an unforeseen oversight of the request received on Saturday, December 24th, 2021. Our office received a follow-up on this request February 23rd, 2022 on the Gov2A portal with another reference number, Paul 063318-022-322. We have been working to fulfill the request, and we will provide additional information on a rolling basis once determined as responsive documents and are non-exempt. SFPD apologizes for any inconvenience this may have caused. Thank you.
Okay, thank you. Thank you. Questions, Member Stein?
Laurie, you're on mute.
That slows things down. My question is for the petitioner, which is within this particular case, what would you consider to be evidence that they failed to preserve or maintain records?
Sorry.
Can you tell me where in this case you see evidence of the SFPD Director of Communication failing to preserve or maintain records?
Because if you don't conduct the search at the time you receive the request, you can delete the records in between. And I'm not sure if they've told you, I believe they've only conducted the search later on. They did not conduct the search when I actually made the request.
But beyond that, you don't have, there's nothing you can point to that shows that they definitely didn't preserve or didn't maintain records.
No, you'd have to ask them when they did the search. I can't show you what I don't have.
Okay, and then willful violation of the Sunshine Ordinance. I wonder if you can speak to that, like where you see the evidence that it was a willful violation.
Sure. So you have found in order, I believe it is 19098, that they cannot give you whatever they're doing here in terms of like taking pictures of other records. You found that the police department violated the law by not producing exact copies of records at that time, and you ordered them to do so. And Chief Scott, who is the police department head, has an obligation to implement the Sunshine Ordinance within his department. He continues to not do this. And I can enter order 19098, which is your own order about the police department doing this.
Okay, thank you. Those are all my questions.
Okay. Yeah, I'm looking at anything I may have had questions about, but I think that they've been answered. So I don't have any questions. Just to sort of look at the case and comment on it, it seems like some of the issues, obviously, we can't decide, so we just have to figure out the basics. It does look like there's a delay issue, and whether the delay is somehow permissible, that's not a decision we can necessarily make. Willfulness, I could see that there's an argument for willfulness, but again, that's not a decision we can make. Member Stein, do you wish to make a motion on this one?
Yeah, I'm kind of on the same page. So I would say the records are public and within our jurisdiction, and that we forward it to the full task force with the recommendation to look particularly at 67.21, failure to provide information in a complete or timely manner, and 67.34, whether there was any willful violation of the Sunshine Ordinance.
I'll second that. Public comment?
Okay, hang on. I'm there with you. We have public commenters on this motion.
Peter Warfield.
Okay, we have a public commenter. When you're ready, Cheryl.
Mr. Warfield, are you ready?
Yes, just let me know when to start.
May begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, P.O. Box 170544, San Francisco, California 94117-0544. Certainly, we're not a party to this, and we're not familiar with the details, though we have heard the hearing. It seems to me that when a petitioner very specifically makes specific requests for violations to be found, I'm not sure that all of the different ones that were cited have been discussed as to why you are not specifying those as things of particular concern. In other words, you've specified, I believe, 2, but not 2 others. So I guess I wish it were clearer from your motion and also from your discussion exactly the reasons why you have determined that the ones you don't include in your motion are less or perhaps not at all significant. I guess another thing that I, in general, would consider important is that presumably the police department, to function properly, has to keep very, very good records and very accurate records, and has to have procedures in place to handle all of the legalities required. And so, once again, I think that it would also serve yourselves and the petitioner and the public to understand that when there are violations, you, for the purposes of your job as watchdogs of Sunshine, need to have a really good understanding of what happened, why it happened, who made the decision, and so on. And so I would urge you to at least consider including those kinds of questions to be considered by the full task force, so that we all have a better understanding of how these things happen, but also what needs to be done, for example, in your order of determination, to fix those problems or at least mitigate them. Thanks very much.
All right, thank you. Let's go ahead with the vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Chair Schmidt, to find that the records are public, there is jurisdiction, and to forward the matter to the task force with a recommendation to look at 6721 and 6734 of whether there was a willful violation of the ordinance.
Thank you. Let's go ahead and hear the Dreckmeyer case, 2201.
Item number 10, file number 22018, complaint filed by Peter Dreckmeyer against the San Francisco Public Utilities Commission for allegedly violating Administrative Code Section 6721, by failing to respond to a public records request in a timely and complete manner.
Okay, is Mr. Dreckmeyer present?
Yes, can you hear me?
Yes, we can. Thank you. And is
Great.
there a representative of the PUC?
Yes, this is Maya Sa. I'm representing PUC.
Okay, great. Thank you. So we've looked at the file on this. I think we understand the issues. There's a 67.21 alleged violation. We'll hear from the parties, each for up to 5 minutes, beginning with Mr. Dreckmeyer, when Cheryl indicates that she's ready.
Mr. Dreckmeyer, are you ready to begin?
I am.
Go ahead, sir.
Okay, thank you for this opportunity. My name is Peter Dreckmeyer. I'm the policy director for the Tuolumne River Trust. And our organization was founded in 1981 at a time when more dams were planned for the Tuolumne River. The Tuolumne is where we get our Hetch Hetchy water. Our organization was founded to stop those dams, and we were successful in 1984. We secured federal wild and scenic status. It was a pretty amazing national campaign. And since then, our organization has grown and we work throughout the watershed. We have a lot of great accomplishments and we're well respected. And I've been working for the Tuolumne River Trust for the last 15 years. And in that time, I've worked a lot with the San Francisco Public Utilities Commission, and at times it's been very collaborative, and at times we've been more like opponents. But in the past, there's been more respect. And when we would ask for information, we would often get it. Then we got to a point where the SFPUC started hiding information, and we had to start filing Public Records Act requests. And more recently, we were denied a Sunshine Ordinance request. And it really baffled me because it was such a simple request, which I'll get to in a minute. But our role is really important because what we found, especially in recent years, is staff will produce numbers that are quite alarming when it comes to San Francisco leaving more water in the Tuolumne River for environmental purposes. And there are efforts by the state Water Board to improve flows, by the Federal Energy Regulatory Commission. So this is a really big deal, and it's part of a much bigger campaign to restore the Bay Delta. But what we've heard from SFPUC staff is, well, if we give up more water, we're going to run out or we're going to have dramatic rationing. And so what we've done is we said, well, you're giving us a number for potential rationing, but we want to know how you got there. And so, for example, we created a water supply calculator where you could put in all the inputs and see what the outcome is. And we had a lot of trouble getting the data from them, but eventually we did. And in this case, a year ago, a little bit more than a year ago, the State Water Board issued something called a water quality certification. The SFPUC responded saying this could lead to 75 to 90% rationing, pretty alarming figure. And that was repeated by then City Attorney Dennis Herrera, who is now the general manager of the SFPUC, in an op-ed in the Chronicle. And so earlier this year, I submitted a Public Records Act request asking for the data and calculations and assumptions for getting to that number. I mean, if you're going to publish a pretty dramatic number like that, you probably did some analysis. And in the long term, I was denied. This is the first time I've been denied. It's the first time I filed a request since Dennis Herrera became the general manager. And I think it's just so clear that basic data like this cannot be withheld from the public. Their reasoning was attorney-client communications. And the only thing I can imagine is that, oh, well, we sent these documents to the city attorney last year, and so it's covered. But by that reasoning, any document could be withheld from the public simply by sending it to the city attorney. So I'm asking that you help me get to a point where they will produce the information. We can come up with our analysis of it, provide it to the SFPUC commissioners who are responsible to the public. We also share information with the mayor's office, with the State Water Board,
with a lot of others, and they depend on us to cross-check this information coming from the SFPUC. I'd be happy to answer any questions.
Thank you. All right, now we can hear from the PUC when Cheryl's ready.
Thank you. Cheryl, let me know when my time starts,
Just
please.
a second. Just a second. Are you ready, ma'am?
Yes, I am.
Go ahead.
Thank you. Good evening, everyone. At first, I'd like to just state that the PUC strongly supports the policies of the Public Records Act and Sunshine Ordinance and works diligently to respond to records requests, including to those submitted by the complainant, always with a view towards the policies and as required by law. As mentioned by Mr. Dreckmeyer, he has submitted public requests in the past. I did a quick gather of the information I had, and the complainant has submitted 6 public records requests to the PUC in the past 16 months. We released approximately 600 records to the complainant in response to 5 of his public records requests. And of the 6 requests, the request that is now before this committee is the only one where no records were released due to privilege. In this specific case, SFPUC properly invoked the attorney-client and attorney work product privilege exemptions from Section 2724 Subdivision K of the California Public Records Act to withhold information that the complainant requested in his January 31st, 2022 request. And the PUC cannot waive the privilege in the information that the complainant has sought. Specifically, PUC is currently a party in an adversarial administrative proceeding and in pending and future anticipated litigation, concerning a water quality certification, as mentioned by Mr. Dreckmeyer. This water quality certification was issued by the State Water Board. The complainant, Tuolumne River Trust, is participating in the specific administrative proceeding in opposition to the city. The information sought by the request was prepared in consultation with the city attorney's office to specifically inform the city's position in the pending administrative proceeding before the State Water Board and even potential litigation. Therefore, that information is privileged, and accordingly, PUC cannot waive this privilege. Thank you.
Thank you. Member Stein, questions?
Yes, I have some questions for the respondent. Can you describe in a little more detail what the process is for coming up with calculations of water rationing needs?
I do not have that information. I'm sorry.
Okay. Can you tell me how city attorneys are involved in calculating water rationing needs?
I was not part of that process, so I cannot answer that specifically. I do not know.
Okay. Let's see how to put this. Is calculating water rationing needs something that the PUC considers part of its typical business or ordinary course of business, something that they need to do as the PUC?
Mm-hmm.
Yes? Okay, and are you aware? Oh, go ahead.
Assume so. I assume so. As you probably know, PUC is a quite large organization. I don't work directly with water staff, but that would be my assumption, but I am not sure.
Yeah. Okay. And then are you aware that the Sunshine Ordinance under 67.24, section B2, talking about public information that must be disclosed, basically says that you must release documents received or created by the department in its ordinary course of business that were not attorney-client privileged when they were created or received.
This specific set of documents and information, I guess, was produced by PUC to, as requested by the city attorney's office, for this specific water quality certification procedure before the state water board. So my understanding is that this information was created in consultation with the city attorney's office for this specific proceeding, not before that. So,
but it is in the ordinary course of business of what the PUC needs to do is produce this type of information for other agencies.
I do not know. I don't know the specifics of the calculations and wouldn't be able to understand, right, what kind of information what calculations we are doing regularly and what kind of specific information were prepared for this specific proceeding.
Okay, those are all my questions.
Okay. Just a bit of a clarification. The file says that you claim that these were attorney-client privilege documents, and this is to the respondent. But in your introductory, you also cited work product doctrine, and I'm wondering, could you, how much of this documentation was covered by attorney-client privilege, and how much of it was a work product doctrine? Because when you just said attorney-client privilege, I really was wondering what's going on here. But now it sounds like it's a little bit of a different story. Could you explain?
Can you rephrase your question? Are you asking what portions of?
Well, yeah. Apparently some of it you've withheld based on attorney-client privilege, and some of it you said you've withheld based on the work product doctrine. How much?
Actually, I have the request, my response open in front of me. And I believe we filed the records based on the attorney-client communications exclusively and not the work product. So let me correct that.
So it's not work product you're claiming, correct?
Yeah, I don't think so. Yeah, I think that there's probably a mix-up with my talking points here, but yeah, I'm opening the request, and the records were withheld as attorney-client, not a privilege, not
attorney-client privilege, and so can you tell me with the documents that are withheld based on attorney-client privilege? Are any of those documents that were generated within the PUC, but you're claiming the privilege merely based upon the fact that they were eventually sent out they were forwarded to attorneys, and therefore the privilege is being claimed?
The calculations were prepared to support, instruct, I'm not sure what the right terminology is, this state water board proceeding. So the water quality, they were created to support a petition regarding this water quality certification.
So are you saying that there is data, that there are numbers that were sent to the State Water Quality Board that would also be responsive to the request by Mr. Dreckmeyer, but you can't supply them because of attorney-client privilege?
Yeah, so the calculations were prepared for this specific proceeding where the Tuolumne River Trust is participating in opposition to the city. So there is a current proceeding, and Mr. Dreckmeyer, the Tuolumne River Trust, is opposing the city's position.
And so you've given some of the data to the State Water Control. I'm sorry, what's the name of the body? Water Quality Board or Water Control?
The State Water Board, and it's a water quality certification.
Okay.
But it's the State Water. Yeah.
Okay. And so some of the data that Mr. Dreckmeyer's organization has asked for is data that you've given to that board, correct?
I believe so. I'm not privy to all the information that was provided to the State Water Board, but I would assume so.
Okay. And my question to Mr. Dreckmeyer is just, I know there may be other types of data that you're interested in, but if there is data that they've given to the water board, is that something that you would like to have and you haven't been given?
Thank you for giving me another chance. So just to explain the whole process, it was in January of last year, 2021, that the State Water Board issued the water quality certification. Tuolumne River Trust and our NGO partners, we filed a petition for reconsideration that basically said we'd like a lot of what's in this certification, but there are a couple issues where we think there could be improvement. The SFPUC and others also submitted their petitions for reconsideration. That was in the SFPUC. First of all, they used a demand projection that was 20% higher than the actual demand at the time, which we caught right off the bat because that was in the document. But then the 75 to 90% rationing, there was no backup to that. So the State Water Board doesn't have the data. They just have the product of 75 to 90%. So that was in February, we filed our petitions for reconsideration. It wasn't until May 13th that the SFPUC filed its lawsuit. So back to Member Stein's comment, the petition for reconsideration was filed first and the lawsuit came 3 months later. And what's happened in the past is we get the data, we look at it, we come up with a different narrative than the SFPUC, we get an audience, people listen to it, and we come out looking pretty good. And what happened this last January, we all filed responses to requests for reconsideration. And so this process goes on for a while. And in the SFPUC's response, they said, oh, and TRT and NGOs might say this or that. So they tried to preempt because they knew what we were going to target in their comments because they knew where they were fudging. And so they tried to be preemptive. And in this case, it's pretty obvious to me that they either didn't do a very thorough analysis to come up with 75 to 90%, or there are a number of assumptions in there that are not reasonable, and they might get identified if we have access to the data.
Okay. And have you requested this kind of data before in sort of like prior periods, and you've been given it in a certain form?
Well, you know, a comparable example was when the State Water Board issued something for the Bay Delta Water Quality Control Plan, which is a pretty big deal. And the SFPUC put out numbers like, oh, this, you know, astronomical socioeconomic impacts. Well, we held a workshop in front of the State Water Board, and they ended up agreeing with us that they were totally inflated. And then their own documents eventually proved that they had exaggerated the impacts by 2.5, so 250%. And so when they came out with numbers about, well, the Bay Delta plan is going to lead to 50% rationing, we said, well, you know, we'd like to have the numbers because we created this calculator where we can, you know, follow whatever process you used and check it. And they said no. And we asked Commissioner Moran to set up a meeting with the staff, and so they did. And we presented the results of our calculator, but we pointed out we had to guess at these numbers here because staff wouldn't give them to us. And a senior staff member said, well, we didn't know how you were going to use the data. And I looked at Commissioner Moran and I said, that's not their role to question how we're going to use public data. We represent a pretty major public constituency, and we have the right to this data. And lo and behold, we got it the next day. We were able to complete our calculator, and ever since then, we've been showing a number of scenarios where we can improve the Tuolumne River ecosystem and keep the salmon from going extinct, and we don't have to worry about running out of water. And we've embarrassed the SFPUC staff a number of times, not intentionally, but you know, we have our job to protect and restore the Tuolumne, and honesty is so important. And I'm proud to say we've never been caught lying. We almost always are right, and I think we will be in this case too if we get the data.
Okay, thank you. Yeah, we can only do what we can do here, and what we can't make any decisions in this committee, but we can send this for a full task force hearing. My take on this is, yeah, it sounds very odd, if not borderline unbelievable, that everything that comes within your request would somehow be covered within the attorney-client privilege. That is, and if that were so, I don't know what kind of business they're running down there, because yeah, you don't put all your data into letters to your lawyers. This just doesn't. I mean, it's conceivable, and that's why I was wondering, did they mean to say work product doctrine? I don't know, but this just, yeah, there's just, it doesn't sound right. So I think we're going to have to send this to the task force to look at, although the problem for us is that when attorney-client privilege is claimed, we have very few capabilities in terms of like digging into the issue, because we can't ask for things like privilege logs. So I am going to say I do have a concern that this doesn't sound right. That's not necessarily something that I'm going to put in my recommendation of the task force, but I think that I am going to make a motion that we do move this forward, and have the task force consider whether there's violation of 67.21 by asserting the attorney-client privilege as an exemption to production of all the documents containing the information you're seeking, sought by the petitioner.
Can I just say before you, I don't know if you were formally making that motion, if we're still discussing it, because we haven't discussed it yet.
Yeah, yeah, let's discuss it. Yeah.
I want to say, I hear what you're saying about attorney-client privilege, and it becomes difficult for us to evaluate. But my concern here is that I feel like the information that's being asked for goes to the core of the kind of information that should be public. This is information that should be produced by the Public Utilities Commission. It's being presented to a public state agency, right? The State Water Board. And yet we're being told that the calculations that produce this information are somehow not available to the public due to attorney-client privilege or work product. I don't understand, and the respondent has not been able to tell me how attorneys are involved in the calculation of this information, and I can't even begin to understand why they would be involved in calculating numbers that are being represented before another state agency. And it seems like those calculations should fundamentally be public information. If it's produced by a public agency, being presented to another public agency, regardless of whether there's a lawsuit. Now, there may be materials in that documentation that discuss the lawsuit or something, and that can be redacted or exempted under attorney-client privilege, but I don't feel that we've gotten any kind of satisfactory answer from the respondent about what attorneys have to do with the calculations of water rationing that are absolutely the business of the PUC. And so I would also suggest that we have the task force look at this being a violation of 67.24B2, which says that you must release documents that are created by a department in its ordinary course of business, that are not attorney-client privileged when they are created. So, I would want to throw that in there too.
I'm with you 100%.
Okay. And I would just kind of say to the respondent that I hope you will do your research and try to figure out exactly how attorneys were involved in calculating water rationing.
Yeah, this does.
Before this goes to the full task force, because that's going to be a central question.
Yeah. Well, my motion was a first draft. I'll certainly add in the additional provision that Member Stein has just recited.
67.24B2.
Sure. That sounds good to me. If you want to, we could further talk if you think we should augment it at all, or else if you want to just consider that motion, that's my motion at this point.
I will second that.
Okay, great.
Okay, so it's a combination of the two motions. Let's see, by asserting claim.
But I will say it's my motion with the addition of that provision that Member Stein added in 67.24B2. Yeah. That's my motion, and that's what she seconded.
Okay, so do we want to open this up for public comment?
Yes. Any public commenters on this item?
Anonymous number 3.
Anonymous number 3. Any others? Let's go forward with anonymous number 3 then.
Are you ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous number 3. Here's what I heard in this case. Basically, an agency was caught lying to another agency in past similar cases. The people who had the resources and were smart enough to catch this agency lying, which is the petitioner and or their organization, are now essentially being shielded from that information by using attorney-client privilege to claim that calculations that are themselves not requests for legal advice are somehow attorney-client privilege. So basically, they found a way to show that an agency is a liar, and now we're going to use attorney-client privilege to make sure they can't be embarrassed again. And that's what I've heard here. Completely agree with the motion. Also, even when state courts have considered this kind of this litigation document, it is only limited to, quote, a document is protected from disclosure only if it is specifically prepared for use in litigation. And the lawsuit is litigation, but getting some sort of permit is not litigation. And in fact, this task force, maybe this committee, has discussed how administrative actions like the SOTF is not in and of itself litigation. So the documents that were prepared, and by the way, the citation for what I just said is City of Hemet versus Superior Court, 1995. But this task force has itself discussed how litigation is something different from administrative action, and the lawsuit may be litigation, and the documents specifically prepared for that lawsuit may be exempt when done in confidence with their attorney. But the other things they have done to argue for why certain kinds of rationing are true or whatever have nothing to do with the exemption they have cited. And if at the end of the day they have to change their story at the full task force, and they are not using actually the same written exemption they used in the response to the complainant, which I believe you've stated was attorney-client privilege, if they change their story, make it attorney work product privilege, make 6254 B for pending litigation documents, whatever they do, then you should also find a violation of 6727, because they are required to give the full exemption for all of the information they want to withhold at the time of the request to the original complainant, and not make things up and change their mind when they get called on it at SOTF. Thank you very much.
All right, thank you. I think we are ready for a vote.
How about public comment, please?
Oh, we have another public commenter.
Mr. Warfield, are you ready?
Yes, just let me know when to start.
Go ahead.
Peter Warfield here, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this case. We have heard the whole hearing, and I want to say that I listened with pleasure. I appreciated very much both the chair and Member Stein in their questioning. I thought that the questions were exceptionally apt and the responses unbelievably weak, evasive, or I don't know. The claim that there was attorney-client privilege and work product is clearly a stated response from the respondent on page 341. Although I heard her testify that she was dropping the work product privilege and was going to stick with attorney-client privilege. What new excuse are they going to come up with, or what old excuse are they going to dig up? It sounded pretty much they were grasping at straws, to say the least. And I love the question, what does attorney-client privilege have to do with these sorts of calculations that can be expected to happen in the ordinary course of business? And certainly, Anonymous is right. There's no indication anywhere that having a lawsuit going does or should in any way affect information requests under Sunshine or the Public Records Act. So it seems that you have gotten spot on, including the additional section, and I'd urge you to consider Anonymous's recommendation of adding the section he recommended as well. And good for you, and yes, approve the motion.
All right, thank you. Let's go ahead with the vote.
Member Stein?
Aye.
Oh, actually, no, this is Dean's motion. I apologize. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to find that the records are public, there is jurisdiction, and to forward the case to the task force and have the task force consider violation of 6721 by asserting attorney-client privilege as an exemption to all the documents sought by the petitioner and consider a violation of 6724B2.
Good. Next item.
All right, next item. Item number 11, announcements, comments, questions, and future agenda items by members of the complaint committee.
I don't have anything.
None here.
Okay.
Hang on a second. Okay.
I guess we should allow public comment on that. We didn't have anything at the end there. Is there anyone who has any comment on that?
Yes, there is.
Okay, we have comment one. When you're ready, Cheryl.
All right, Mr. Warfield, are you ready?
Yes, just let me know when.
Go ahead, sir.
Peter Warfield here, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. One of the items on this agenda, item number 11, is future agenda items. And while it says by members of the complaint committee, I would comment on the absence of recommended future agenda items and suggest something that you, I think, should consider. Today, you've heard a lot of testimony by people who were largely, if not completely, uninformed about the cases, about the decisions made in these cases, about the operation of the department. About the procedures within the department. Member Stein said, what is the attorney's role in the process for calculation that was under discussion? I think that there is a need, number one, to comment on the quality and the believability of testimony given, especially when it is, let's say, severely deficient. And I also think that in the procedures, there ought to be routinely, and perhaps in your hearing you can do it ad hoc, but in general, that there should be a requirement that principles with regard to what happened, in other words, the people who, certainly the immediate decision makers, what to deny, whether to deny, how much to deny, what claims to make, and so on, those folks should be directly giving testimony. And if they don't, and if they're not brought by the agency, the respondent, then you should consider that seriously in your motions, in your comments, in your orders of determination, as part of your decision, as respects their believability, their knowledge, and so on and so forth. Basically, in the past, you used to have orders of determination that would say things like, this side...
Your time's up, sir.
What, is that a 30-second warning?
That's 3 minutes, I believe Cheryl said. Yeah, thank you.
So if I can conclude, I asked for 30 seconds. I thought I was getting 30 seconds. So to conclude, I think that's something you should consider for your future procedures. Thank you.
I would like to comment as well, Anonymous.
Oh, we have another public commenter. When Cheryl's ready.
You ready, sir?
I am.
Go ahead.
Thank you, Synonymous number 3. I just wanted to heartily second everything that Mr. Warfield just said. And this is something as the complaint committee you should discuss when you're talking about complaint procedures. The law already says in the Sunshine Ordinance, in court, if a record is a public record, until they have the burden of proof that it is, they being the city, has the burden of proof in proving that it is exempt. And if the people, and that's about in court. Now you make your own rules, and I believe you have the same rule in your complaint procedure. If people are coming here and they don't know what they're talking about, and it is clear they don't know what they're talking about, you should give their testimony very little weight. And what is very confusing is the fact that there are clearly people in that department who know why they made a decision or are responsible for making the decision. You should consider, why is it that they send other people? One would think the city would win more cases if they sent an expert lawyer who was, an expert in the public records law and could defend their decisions really well. So why is it that they appear to send people who don't know what they're talking about, either or both in the law and worse, in the facts of the actual request? And so I'd very much second everything stated by Mr. Warfield. Thank you very much.
Thank you. All right.
Other public commenters? Okay, I guess public comment is closed.
Next item.
Item number 12, adjournment. I have 8:55.
Okay.
I make a motion to adjourn.
Second.
Okay, thanks. Bye.
Have fun.
Thanks.
Yeah, I've got to stop the recording.